All right, we're going to go ahead and get started. I think Judge Eisnagel may be having some technical difficulties on his end. I don't think he'll mind us getting started since we have another case shortly after this one. We're here on the Velez versus Security First Insurance case. Our case number 5D22-1649. And we're here with regard to consideration of sanctions against attorney Leslie Cabrera. And are you Leslie Cabrera?
Yes, Your Honor.
All right. Would you please raise your right hand and be sworn? Do you solemnly swear or affirm that the testimony and answers you give here will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. You understand why you're before the court?
Yes, Your Honor.
All right. We sent 3 different orders. Each one required a response from you. And to none of those orders did you file any response. The whole idea behind sending an order out, especially the first one, we wanted to know why the appeal was being taken and whether it should be dismissed. I mean, at that point, you want to talk about judicial economy and economy for yourself. That's when you respond. The second order, we gave you a second chance to say why your case shouldn't be dismissed, and you didn't respond to that. So on our third order, we dismissed it and asked you to show cause why you shouldn't be held for sanctions or sanctions imposed against you, and you didn't respond to that either. Am I correct with all that?
Yes, sir.
Can you please explain to the court why you chose not to respond to each of those 3 orders?
Yes, Your Honor. First and foremost, I would like to preface that was not intentionally done. When this case was dismissed, it was set up for appeal. I received my first order, which was for July 14th, 2022. I went ahead and I sought help from my supervising attorney. We went ahead and I took a look at the cases that were cited. And it looks like I probably misinterpreted the law in those 2 cases that were cited, because in an attempt to respond to the order to show cause as to the July 14th and the July 27th, the course of action my team decided to pursue was to file the petition for writ, which was filed on July 27th. I was mistakenly under the impression that that petition for writ in and of itself would have responded to the order to show cause, not only for the July 14th, but also for the July 27th. Clearly, that was not the proper way into which respond, which now I'm aware of. At the time, when I read the case law that were cited in the July 4th order, it was the one for FedNat Mortgage Association versus Leonard and Hinault versus Ford Motor Company. When I took a look at the Federal Nation Mortgage Association case, that case was talking about a case that was dismissed with prejudice. So I was under the understanding that it wasn't applicable in my case. And it's in my case, the case was dismissed without prejudice. Since the case was dismissed without prejudice, I was under the understanding that this was not a final order. So the petition for writ was in an attempt to provide jurisdiction to this court to entertain the appeal. As to the August 17th, 2022, Your Honor, that was unintentional. It wasn't done purposefully to ignore this court at all. I actually, for that specific order, I was trying to seek some help from my supervising attorney to properly respond to the sanction. That did not fall through, Your Honor. I cannot explain as to why the August 17, 2022 order was missed. Must have been some miscalendaring issue on my part. I reached out to the proper sources just to get some assistance as to how to properly respond to this court. That didn't occur. And then of course I received the September 14 order, and I did all the proper procedures to try to obviously appear and show face to this court and to let this court know that this was not done intentional. This was not done purposefully done. And that's why, respectfully, Your Honor, I'm trying to obviously seek to not have sanctions imposed on me.
It's remarkable to me Not that you took the appeal and then changed over to assert. That may be just fine. I'm not passing any judgment on that. Sometimes people file appeals out of an abundance of caution, worrying that if they let the 30 days go by, they may be in trouble. But we try to be very clear with our orders that we ask you to respond to the court in this case. And I understand you're saying it's not intentional, and I can tell from your demeanor that you're sincere with that. But it's kind of hard to understand how you accidentally don't respond to three different orders. I could understand, one you may have misunderstood, you thought you might have corrected, but when you have three orders, each of them telling you, and by the time it gets to saying, you get back in touch with us or we're going to sanction you, at that point, I'm at a loss to understand. I hear what you're saying and I take you at your word, but number one, this should never come up again. If it does, and I don't care what court it is, I don't care if it's small claims court or the U.S. Supreme Court, if a court orders you to file a response, even if it's not a good response, even if you need more time, saying something is considerably better and more understandable than saying nothing. We're not here to punish people or chew them out. That's not what the purpose is. We're here to understand what's going on. Sometimes people have problems and they explain it to us. Here, I think this is a mighty tough way for you to learn a lesson that you really already knew. And that's when the court tells you to do something, you either do it or you take an appeal. And that way the court knows that you're not ignoring them. Here, we spent more time on a case that was basically dismissed, that never should have been brought, but that's beside the point. We spent more time trying to get you to answer us than we have dealt with any merits of the case. And that's just a poor waste of everybody's time, for the court, the clerk, and for you. And I would hope that we never run into that with you again. And I hope that you would counsel. I know you've been a member of the bar now, it looks like for all of 2 years or so, that in the future, you take the opportunity to counsel with any of your colleagues, younger or older, to let them know how important it is to respond. Do you have anything else that you wish to add?
Just, Your Honor, that the first two orders, the one for July 14th and the one for July 27th, it was my impression that I had already responded by filing the petition for writ. Clearly, that wasn't the proper way to respond.
All right. Do my colleagues have anything to add?
I have one question. Ms. Cabrera, what is the supervising structure at your firm? Do you have someone supervising you on all of your cases?
So what we do in this firm, so right now I'm located in the Orlando office. There's a Miami office. My supervising attorneys are stationed there. If there is a question or there's an issue, what we are to do is we send them an email inquiring, we try to set up a meeting, and we try to figure out a course of action as to proceed for complicated matters that obviously are a little more complicated from my experience. In this case, this was done for the July 14th, and then the course of action that my team advised me to do was to file the petition for writ of certiorari since it was filed on July 27th, which is the same time that this July 27th order was submitted. And my team was under the impression that they had responded not only to the July 14th order, or that we had also responded to the July 27th. Now, as to the August 17th, I did seek out some help. I didn't receive it, unfortunately, in time to be able to properly respond. But I do understand that that's not an excuse, because I should have responded to something, even if it was nothing. I just didn't know. I tried the best that I could to respond to the August 17th order. I just didn't think that I had the skill set to be able to do it by myself. So that's why it was inadvertently missed. I should have responded something. I know I should have. I just didn't know what to put. Obviously, when I received the September 15 order, I was very frantic. So I talked to my team, explained the situation to them, and they assisted me to try to obviously give a proper presentation today in this court. But it was at the end of the day, I am an attorney and I am licensed by the bar. So if there's any sanctions that need to be imposed, then they would just take their full responsibility. But like I said, and I'll preface this, and I'm not, obviously my demeanor is not helping, right? But this was not willful, intentional, and the intention was not to waste this court's time at all. I genuinely thought, and I did the best that I could to respond properly. I have no excuse for the August 17th from I tried the best that I could, and I just couldn't come up with a proper response in time. And then of course I received this one, and I attempted to respond to all the orders and have them submitted before today. They were rejected, and I just decided to just go ahead and proceed this way. As long as the acknowledgement of receipt was submitted properly, and I got the Zoom link to appear today and explain myself and just verbally explain what I was intending to write for all the orders and explain myself the best way that I could. That's all I have.
Is your supervisor aware of this hearing?
Yes, he is.
And Ms. Cabrera, take a breath if you need to. I have one more question, and like Judge Edwards said, I can tell that you're being sincere with your responses. How many appeals have you handled? Is that normally what you do? Or are you mostly in the trial courts?
I'm usually what I am assigned to do is I work the case all the way to it's close to trial, where we're into the pre-trial conference, the final one. The way that this firm works usually is I lay it up for a little more seasoned attorney to handle the motions in limine and actually take over trial and take it from there. Normally, I do not handle appeals.
Okay, thank you.
All right. Anything else, Judge Eisnagel?
Oh, I'll just apologize for being a few minutes late. I was having some connection issues, but I'll make sure to review the hearing from the beginning.
All right.
So that I don't miss any of it.
All right. Well, thank you very much. With that, we will be in recess.
Okay. Do I have to come back, or what do I need to do now?
We will issue an order, and we'll send you a copy of the order.
Okay. Thank you. Thank you, guys. May I be excused?
Yes.